very much for this very challenging discussion, for this very lively afternoon panel. It's my great pleasure now to give the floor to Lucy Reed. She has a mandate, which is to fill my backpack, but also to sort of take us from where we have been the whole day to possible next avenues of exploration, of opening the box to be able to look at it from the outside, going back to the essentials that we shouldn't be dreaming too much about. So I'm really very glad to give Lucy the floor. I think Lucy doesn't require a major and lengthy introduction. But then in this case, in order to stick to time, I think I'm going to give you the floor right away, and thank you very much for being with us and for guiding us through the last part of this seminar. Thank you.
Thank you, Anna. We have a favorite anecdote in our family, which was when we were in church one day with our then young children. There was a long sermon, and when the minister was catching his breath, my young son said, "Too much church." And there's maybe too much investor state, so I will be quick. I can't really wrap up the day, and it doesn't need to be wrapped up because we had the commentators and it was covered live as we went. But I will say I do mediation. I like mediation in commercial cases and in investor state contract cases. We've done it successfully. We don't shy away from it. We don't steer our clients to arbitration or litigation to make money. It's not a problem. The area of treaty, in the investment treaty, ADR is where I'm interested and why I told Susan I wanted to come today and to listen and learn and not so much to talk. So I want to thank everyone. As Professor Reisman said this morning, this is an awesomely organized and executed conference. And as Anna said, my goal, it's impossible to do everything you asked, but my goal is, her goal is to walk out of here with ideas and guidance and areas for focus on agreements that are conducive to ADR and for dispute resolution practices conducive to ADR. And that's true not just for UNCTAD, but for UNCTAD, I'm sure, for MEG and other institutions. One major takeaway, maybe the major takeaway, goes to the conference process, Web 2.0. You have proven that it is possible to have an interactive, productive discussion leading up to a conference, and indeed simultaneously throughout a conference. It expands participation and, as used in the future, can minimize, of course, carbon footprint. The challenge is to make the follow-up as active and productive as the lead-up, and I have no doubt that will happen. Now, if the question is, as Michael McIlraith asked, when will investment disputes include mandatory ADR the way so many national systems do now, my answer is never. That's never going to happen, at least in the treaty area. I could be wrong, but I think the answer is never. It is one thing for the U.S. government to agree to mandatory ADR with employees in different institutions. It's another thing for the U.S. government to agree to mandatory ADR in investment disputes with foreign nationals or for U.S. nationals. Most of my remarks do go to treaties, I will emphasize. But if the question is there room to do more to open the door to mediation, facilitated settlement, problem solving, whatever you want to call it, in investor state treaty cases, to create what someone called, I think Jack Coe, a convening bias, I think the answer is yes. There is some room. The growing interest in this area, having you all in this room, speaks for itself. But it shouldn't be a campaign. I don't think there's a crisis. I don't think we need to be saved from ourselves in the investment treaty dispute resolution world, because there are some realpolitik considerations I'll list before I list some of the shopping list going forward. One is that no one mentioned this today really, but investor state arbitration is an aberration in international law. To have a sovereign on an equal plane with a private entity is an aberration. There are inequalities, sovereignty on one side, lots of money and power on the other, more. They are not going to go away in mediation any more than they go away in arbitration. So we have to acknowledge that. Second, in some percentage of the 318 cases we heard about today, I'd be curious to have someone tally up how many. The relationship between investors and the host state are fractured. They are fractured and irremediable, at least for a decade or so. And that means there's not a future relationship to protect, and that affects design of dispute resolution, obviously. Third, other people have said this, money is not the only issue in many of these 318 and other cases. It is very difficult to mediate jurisdictional issues in investor-state cases and MFN cases. Certainly policy issues are very hard to mediate. When I was working with the U.S. State Department and the Iran-U.S. Claims Tribunal, we settled, without third-party facilitation, we settled a lot of commercial contract disputes between the U.S. and Iran. We never once settled a treaty interpretation dispute, and we didn't have to worry about transparency either. They're just very hard. Now, there's also the problem of authority for states to settle and to voluntarily pay money or not pay money with a private investor. I will give you just a quick anecdote. I told some people last night. I can remember also in the Iran-U.S. Claims Tribunal situation, there was a contract dispute between one of the defense agencies of the U.S. government and an instrumentality of Iran, and I had told my client that we were going to have to pay X million dollars. There was no way around it. And out of the blue, we were offered 1/10 of X million dollars in settlement, provided we could do something, let's call it Y, which I happen to know that we could do. It was actually quite easy. And so I spent a huge amount of time recommending the settlement, and I never got it for two reasons. Interagency review process. Nobody wanted to agree to pay even 1/10 X to Iran at the time because of policy implications in this particular case. And the paperwork was too hard. I could have written 4 memorials and gone to hearing 4 times before I could get this process through an approval. So what happened? We got found liable for X million dollars, and we paid it, and nobody's neck was on the line. So this is a reality. Even if, as Michael Reisman said, there are ineluctably clear outcomes sometimes. So what can our community productively put our focus on a practical level? First, on the agreement and treaty side, we need more attention to stepped processes. We need to articulate expectations and possibilities. We need to make the cooling off period in treaties jurisdictional. Forget for Mahazzini. We need to say there must be consultation. It's not something that you can pick out of another treaty. For the disputes phase, first, let's study the 318 cases. Let's study the 25 to 40%-ish cases that don't go to award, because we need specifics. It's fun to talk theory, but we need to think about specific cases and why we settled or didn't. Second, we need to implement ways to keep the states involved. I really like hearing about the aftercare, the Peru-Colombia Joint Committee models. Third, we need to implement ways to keep all the principals from the states and the investor involved. This is normal from ADR. You need the people who can make the decisions, even if there are several of them, in the room. In UNCTAD, if they had to be at the preliminary session, that would help. If they have to be at the hearing, that would help. Fourth, UNCTAD and UNCTAD and other institutions should think of ways to create a space to publicize and reward success by states in settlements. Without the details of the settlements, obviously, but let the community start knowing which states do settle cases, and it will be a positive factor for investment, potentially. Fifth, let's wrestle with the transparency issues. I hadn't thought about them before today. They're very difficult. Sixth, Let's explore methods for creating this effective capacity by identifying third-party candidates to serve as facilitators, people, or as Lawrence said, states or institutions. Copy Man's pretty busy, but we need some people like that. We don't need, in my opinion, in most cases, facilitators. We need evaluators. This is an evaluative process. We need the great and the good who are experienced in international law and as arbitrators who will say, if you take this to hearing, you will lose on this, this, and this. You will likely win on this, this, and this. The problem is, my great and good isn't necessarily your great and good. And those of us who've had to find chairmen for tribunals know how small the pool of people are unless we're more creative. Seventh and last, what do I think will most work? Two things. Early case evaluation by a third party, great and good person. And second, preliminary assessment by the arbitrators in a case, as they're doing in Zurich somewhat. This could be done early. It could be done with minimal documents, minimal witnesses, maybe even page limits, with principals present. And after shortish deliberations, the tribunal could announce preliminary views, and then the parties could accept some or all of them and go forward with the whole case or part of the case with translating what you can into an award on agreed terms. Or not. If nothing else, this would streamline the arbitration process because it would prove to people how you don't need the binders and binders and binders sometimes to get to the main issues. I would like to see that explored. This is why I'm at the conference. It's for those two possibilities, with my experience, that I consider myself still a guarded sympathizer of the process. And as I step down, I just would like to ask for a show of hands as to whether or who in this audience has changed from being an unrepentant eye roller or a guarded sympathizer or a true believer. Who's changed their position as a result of today?
I've changed twice today already.
Oh, very good. Thank you.
Housekeeping matters. We were going to be drinking soon up in the faculty lounge, and we have an event that's going to be in here at 6 o'clock. So when we move, I'd like to try to move as quickly as we can. But one of the things I would like to address is today has shown me something important, namely that we have a great deal in common, an interest in investment, international law, and process integrity. But as I said last night at the dinner, this is potentially a bit of a marriage between investment and ADR, but perhaps I should adjust my analogy a bit to suggest it's a bit more like dating. But dating can be very fun, trust me on that. So I would encourage us to continue to think about the possible synergies in this area. Before we go, I want to give a big thanks to the speakers, the commentators, the key participants, the bloggers, everyone who's been in this room today, and everyone who has facilitated us being in this room. There's been a huge amount of assistance for people that have made this happen. And I want to just give them a quick round of applause. Specific shout-outs before we go have a beverage of your choosing. Wendy Rice, Administrative Queen. Come on down and get your certificate. We've also had two, oh my goodness gracious, there's more presents.
Wendy Rice, Administrative Queen.
Pete Chatan has also been an amazing force in this event. He's not possible without this man.
That's very true.
Thanks, Pete. We've also had a couple of student liaisons who helped administratively. April and Massey, come on down and get some flowers. But beyond that, each and every single student liaison has made this conference absolutely possible for all of you. We would like you all to come down and get presents, not the least of which is a certificate of appreciation from UNCTAD and WNL, as well as something that's a little 2.0, an iTunes gift certificate. So come on down.
a little token. It doesn't come from Geneva. It's not a cuckoo clock, but it's really for you to enjoy all weeks.